Hello, my name is Gwyneth Alsop. I'm the Managing Director of the Law Practice, a firm of solicitors in Birmingham who specialise in conveyancing for investors. That's people like yourselves who buy, sell and invest in residential property. We've developed a real expertise in these areas and we really understand how some of these deals work and the urgencies involved sometimes. As a result, we routinely complete within 4 to 5 weeks. We return your calls wherever we can, and we are available out of hours. We handle files by email, which of course makes it much quicker and slicker, and we do have a sense of humour. Now, I've been a solicitor since 1984, and over the years, when people ring me up to have a chat or to ask for some advice, it's become quite clear to me that a lot of even experienced landlords are very confused about the basics of assured short-hold tenancies, the difference between a tenancy and a licence, about what an AST has to say and what the notices are all about that are set out in the Housing Act. So what I want to do today is to do a quick whistle-stop tour through the legal framework of the tenancy law, which was pretty much set up by the Housing Act 1988 and has been affected by subsequent legislation, particularly the 1996 Housing Act, which relates to HMOs, houses of multiple occupation. So although there are lots and lots of exceptions to this quick talk, for example, long leases, long residential leases, property that's not in England and Wales. What I'm going to be talking about primarily is the sort of stuff that we're dealing with on a day-to-day basis, that is the residential letting of premises for about 6 to 12 months, but certainly for less than 7 years, effectively short-term lets. Now, there is a lot of confusion, I think, between a licence and a tenancy. Some people think that they can't grant licences, and some people think that licences are absolutely the be all and end all. I had a case down in on the south coast fairly recently where the landlord had actually been living in Hong Kong, so had left control and management of this house. And he'd got one person who was his formal tenant under an AST, and when he came back to the country to try to recover his 3 years of rent arrears, he found out that that named tenant was long gone and that the house was occupied by a number of people that he had no idea of at all. They were neither licensees and neither were they tenants, but equally they were probably not squatters, and we did actually make an application to the court to have them removed by treating them as squatters, but the court said no, that there was an existing AST in place and we had to at the very least do our best to prove to the court that we could find out who and where that tenant was. If we couldn't find out where the tenant was, if the tenant had got relinquished all interest, then the court was prepared to deal with these people as though they were squatters. Now, the basic difference between a licence and a tenancy is that with a licence, the occupier moves into generally room shares or house shares and has very little legal control or anything over where they're living. You know, the situation we all know of is where somebody's got a bed sit in a house or somebody's got a lodger. A very common one is where somebody has somewhere to live as a result of their job, for example, in the old days, not so much now, the police, the fire service, the water board. Now, what's really important, the difference between that and a tenancy, is that effectively when that tenancy is granted, the landlord is giving up to that tenant his legal rights. So pretty much as soon as that AST is signed, it's as though the landlord has sold his legal rights to that property in return for receiving rents. Now I know, because I've had the conversations, that a lot of you guys who are landlords find it really difficult to understand that you can't just walk in, or if you think that the tenant has left but you're not sure, just to be aware of how careful you've got to be to get entry safely without breaking the law. Provided that the tenant has signed the AST, then they've got their rights for what's called peaceful occupation. You can't go in as a landlord to do anything to repair or do any checks or any certification without the tenant's approval. Now, I talked already about the Housing Act 1988. That was necessary because there were a lot of people who were renting premises under the old Rent Acts who really could be in there for years and years and years on, 39 pence rent. So to try to redress the balance, the Housing Act created an assured tenancy. And that was where the tenant has exclusive occupation of all or part of the property, and the landlord has the right to charge a market rent. The statutory exclusions to that are where we have holiday lets to asylum seekers, college student lets by the colleges, not by private landlords, and agricultural land. Those people the landlords there do not have the benefit of an assured tenancy. Now, nowadays, most tenancies that are granted of residential properties will be assured short-hold tenancies. And these are effectively a subdivision of an assured tenancy. The importance of an assured short-hold tenancy is that at the end of the term, the landlord can get back possession provided he serves the right notices. And that's really important. The right notices are largely the Section 21 notice. It's absolutely vital that you serve the correct notice to the correct people on the correct day, and that it expires and is shown to expire at the correct time. Many possession actions get to court and fail because the Section 21 notice has not been served properly. So just be careful about that. Now, we all talk about an AST, and if you come in to me and talk to me about possession or collecting rents, I will always say, have you got an AST? Can I see it, please? The question is then, really, does an AST have to be in writing at all? And the answer is no. You can create a tenancy relationship by letting the person in and collecting rents from them. But you will have a recipe for disaster. Under the Housing Act, Section 8 enables you as the landlord to get possession proceedings in an expedited process. So you don't have to go to court, it's all a paper exercise. But you lose that right if you don't have a written AST. So, for the sake of probably free in a lot of cases, but maybe 50 quid, and getting the AST document and filling in the core details, which is the stuff at the top that is pretty much self-evident, then you at least get yourself that benefit later in the future. I had a possession claim in Rugby County Court about last June or July, where the possession teetered on whether or not the landlord had correctly filled in his address properly on the top of the AST. He'd got an address, but it wasn't completed properly, and that could have been enough if the judge had chosen to stop that possession action taking place. Now, those things that I've talked about at the top of the AST are what are called the core terms, and there are criminal consequences if you don't give the tenant those core terms within 28 days of being asked for them by the tenant. And those core terms are, and you can guess, can't you, really, the start of the tenancy, the amount of the rent and when it's payable, an explanation of any rent reviews, and the length of the fixed tenancy. Now, in another talk, I will look at Section 8, Section 21 notices. I will look at what happens when your AST fixed term expires, but we don't have time today. What I've tried to do today is give you a basic understanding of the framework of the papers and the documents that you use and the words that you use. I'm going to ask you to make sure that you always use the correct forms. If in doubt, get expert help, and if necessary, and if you get to that stage, come and talk to me about your possessions. So thank you for listening. If you want to keep in touch, then there's a free AST on our website, and you can also register to receive my blog if you don't already get it. The link for it is lplawfirm.com/blog, or there's a link direct on our website, lplawfirm.co.uk. The blog is up to date and topical. It's written the way I'm speaking to you now, and just give you the opportunity to actually respond or ask questions. Thank you.